where she became a partner. Sorry, I'm just getting a prompt here. So that is our distinguished panel for the final round. And with that being said, I hand it over to Chief Justice Winkler to preside this round. Thank you to all our panel.
Thank you very much, Jesse. Could I just ask you a question before we begin? Which view would you like us to be on? I'm on gallery right now. Would you like me on speaker view, or is gallery okay?
Gallery view would be best. And if you right
Yeah, I'm on gallery now, so I'll just stay there. That's fine. I just wanted you to tell me.
And then you can hide the non-participants.
Correct. Okay.
Perfect. Okay.
Thank you very much. So we'll call this this court to order. And is the registrar there? I don't see the registrar. Hello?
I am here.
Okay. Now, do you want to, can you put us onto the speaker then, please, for the plaintiffs? Do you want to give us the order of appearances?
Sure, just give me 1 second.
Okay.
Two P and 4D.
Who are the people's names? Are they going to tell us themselves?
Yes, they will.
All right. Okay. Now, I don't need the code names for them. So go ahead. So could we then see the counsel for the plaintiffs, please? Hello and welcome here. You're both on moot at present. So who wants to proceed then? Very good. Mr. Murphy? Go ahead then, Mr. Murphy. That's your pleasure.
Good afternoon, Chief Justice and Justices. My name is Griffin Murphy, and I'm here today with my colleague Sean Gruhe to represent the Roses, who seek to certify an action for charter damages pursuant to the Class Proceedings Act, or CPA. While spring is normally a welcome sight in Ontario, April 2021 instead saw the blue lily disease press the defendant into making snap decisions. Now, certain responses to protect the health of Ontarians may be commendable, but the defendant's travel restrictions withheld Canadians like the Roses of their mobility rights entrenched in our Charter of Rights and Freedoms. And every single Canadian denied entrance into Ontario had these rights violated in the exact same way. Today, we seek justice for such Canadians. Specifically, we seek an order granting certification of the common issues, the appointment of the Roses as representative plaintiffs, and costs of the motion. I would note it's undisputed that the class members today raise common issues under 5.1c of the CPA. What we are here today to satisfy in sequence are the remainder of the certification requirements. Namely, I will cover A, that the pleadings disclose a cause of action, and B, that there is an identifiable class. My colleague, Mr. Gruhe, will then cover D, class action is the preferable procedure, and E, the Roses are suitable representative plaintiffs. Now, I ask that you turn to our arguments that the pleadings disclose a cause of action under 5.1a, which are at paragraphs 10 through 18 of the plaintiff's factum. Please let me know when you are there.
Go ahead then, please.
This court held in Buffett and Attorney General of Ontario that the test for 5.1a is a low threshold to meet. It simply requires that it's not plain and obvious the claim will not succeed. Furthermore, unlike the remaining criteria, the analysis turns entirely on the formal pleadings of the representative plaintiffs. I now move on to the defendant's violation of Charter Section 6.2a, which guarantees the right to move to and take up residence in any province. the defendant's orders prevented the Roses from taking up residence in Ontario. Now, residence has been given different contexts in different legal jurisdictions, but it has not been given a proper definition in a 6.2a context, given the limited jurisprudence here. Given this ambiguity and the low bar for certification, residence should be defined at a common issues trial rather than at this stage. But the limited jurisprudence on 6.2a supports
Well,
the Roses.
why should residence be, why should that be defined at the common issue trial? I mean, doesn't it have to be decided now?
No, Chief Justice.
Well, how can you certify it if you don't define it?
At the
Now,
certificate?
I mean, you may have to determine or discern whether a particular person has residence or not later, but why would that issue not be decided now as a condition precedent to getting a certification order?
At the certification stage, the analysis in the 519 test is that it is not plain and obvious the Roses have not taken up residence. That is what is under review today. But with respect to why it's more relevant to define it at a common issues trial, both parties ought to have time to prepare and advance evidence on what the concept of residence is under Section 6.2, which can take place at a common issues trial.
Okay, well, I think that satisfies my question there, but aren't these people really just itinerants? I mean, your clients, the Roses and Roses, I mean, they're just, it seems to me like they're like tourists. But I guess you say you don't have to deal with that now. Anyway, you'll hike that to the common issue trial?
That will be better dealt with at a common issues trial. However, the concept of moving to and taking up residence guaranteed in 6.2a, as held in Kohler in Newfoundland and Labrador by the Newfoundland Supreme Court, the wording supports the right to have multiple residences in multiple provinces. And in that case, living for even a few months in a province disclosed a cause of action for a 6.2a breach. Now, in the facts at hand, the Roses plan to take up residence in Ontario for 4 to 5 months. But the defendant's exemption order did not capture Canadians who take up residence in the province for that amount of time. Therefore, the orders collectively deprived the Roses of their 6.2a rights. I now turn to Section 6.2b, which guarantees the right to pursue the gaining of a livelihood in any province. The orders violate the Roses' rights by preventing them from pursuing such a livelihood in Ontario. Justice Laforêt held for the Supreme Court of Canada in Blackened Law Society of Alberta that provinces cannot regulate interprovincial mobility rights of Canadians pursuing their livelihood, as this would derogate from the inherent rights of the citizen to be treated equally in their capacity as a citizen throughout Canada. Now, the travel ban order clearly results in unequal treatment. It effectively creates two classes of Canadians, with permanent residents of Ontario on the one hand, who are able to pursue their livelihood as they wish, and Canadians such as the Roses on the other hand, who cannot enter Ontario to do so.
Mr. Murphy, I've got a question for you. The Roses really are not gaining their livelihood by operating the inn, right? They've got a manager. So what am I supposed to do with that in my analysis here? Like, couldn't they have just continued to operate the inn using their manager, even if they couldn't come to Ontario?
I have two responses to that, Justice. The first of which is many losses happened less than 6 months into this pandemic, and it may be harder to mitigate such losses from a virtual capacity, with of course, they're demanding a full evidentiary analysis to do so at a common issues trial. But second, and more importantly, the onus of 518 is not on the strength of merits, but on the content of pleadings. Here, simply put, Section 6.2b guarantees equal treatment regardless of province, and a distinction between virtually delegating the affairs of the business and in-person work, which permanent residents of Ontario were able to do. That's still very much a distinction as contemplated by Justice Laforêt, and is completely opposite to what Section 62B stands for.
Okay.
And a final note on Section 62B, the exemption order also violates the Rose's rights. It was held in Kohler, the province violated these rights because the order did not account for the plaintiff's specific circumstances under any of their exemptions. Here again, the defendant's exemption order includes individuals fulfilling a short-term full-time work contract, but this does not extend to self-employed individuals like the Roses. So applying this, the orders separately and collectively violate the Roses 62B rights. Moving on now to Section 24.1 on charter damages. Damages are justified for 3 reasons. The first of which is they fulfill the functions of Section 24.1 as set out by the Supreme Court of Canada in Ward and Vancouver. The functions being compensation, vindication of the plaintiff's right, and deterrence of future breaches. In this case, all 3 are met. Compensation, which Ward states is usually the most prominent function of charter damages, is clear here given the Roses have suffered business income losses of over $37,000. But the functions of deterrence and vindication are also highly relevant. The defendants enacted their orders against their own advisory board's recommendations without communicating whether alternative solutions were considered. And the Chief Minister of Health grants discretionary exemptions without transparency, including exemptions given to a celebrity and a political donor. So while the gravity of blue lily disease is evident, the defendant has violated charter rights in a manner where they are held unaccountable. But
that
damages can
advisory
provide...
report was from February, right? And the restrictions were enacted in April. I mean, it's a pandemic. Things are unfolding as they go. So how much weight can we really put on that advisory report?
The weight of the advisory report recommendation shouldn't change much, if at all, over the 2 months. Being sympathetic, of course, to the changing facts of the blue lily disease, a major reason why the advisory board made its recommendation was because of the constitutional considerations at play. And the constitutional considerations did not change over that 6-week period between the advisory board's recommendation and when the travel ban order was put in place.
So what's the relevance of this advisory board report anyway? I mean, isn't that to supposedly advise the government? Who's that supposed to advise? The whole world?
The advisory board is meant to advise the government on the most effective plan of action given their expertise, both within health and in constitutional law. So,
but are they bound to take their advice? I mean, isn't advice just advice? And so lots of people don't take advice. I've noticed that in my career, you know, like a lot of people think advice is annoying. They don't take it. And maybe the government are the same. Maybe they just thought the advisory board were annoying or something.
Chief Justice, I can't comment on the defendant's thoughts on the advisory board in particular, but I can comment on their sufficient blameworthiness to remove any good governance considerations, in which case the advisory board is highly relevant. The Court of Appeal for Ontario held in Francis in Ontario that the minimum threshold of fault applies here, which is governmental awareness of a real likelihood or real risk of charter violations. So here the defendant heard the advisory board's recommendations in February of 2021. Months later, again, this court opined in Daffodil in Ontario, even transitory visits to Ontario may satisfy the low bar for residents to be protected under 6.2a. The defendant has been clearly aware of these charter risks, and yet the orders still remain in place. So given this clear disregard of charter rights, a limited immunity for good governance concerns cannot be advanced. If there are no further questions, I will just conclude the charter damages analysis. The last reason charter damages are justified is there is no available alternative remedy that would negate charter damages, the analysis of which I leave to paragraph 16 of the plaintiff's factum. And I will now illustrate why there is an identifiable class under 5.1b of the CPA. I would ask you turn your attention to our class definition at paragraph 19 of the plaintiff's factum and our arguments which follow on through to paragraph 27. If you could let me know when you are there, I will resume.
Okay, I think we're there.
So the proposed class definition fulfills the requirements for 5.1b set out in Bywater and Toronto Transit Commission for 4 reasons. First, the class definition is rationally connected to the common issues. Second, it is adequate in scope. Third, it is based on objective criteria. And fourth, it has 2 or more members. Starting with rational connection to the common issues, all class members are connected in the sense that their section 6.2a rights were violated by being prevented from taking up residence in Ontario on a non-permanent basis. The claims of the class members at this stage don't need to be identical, and not every class member must have a provable claim. It's simply enough that all members have a rational connection to this common issue of a charter breach. Even Canadians without claims to lost earnings, such as wedding guests, may share damages for harm to their intangible interests, which the Court of Appeal for Ontario stated in Meekis in Ontario can include distress, humiliation, embarrassment, and anxiety.
So you'd say this would be like the Walker and Water dispute then, where people were in the class, even if they were just traveling through Walkerton and had a glass of water and suffered harm, they would be then in the class. Is that your proposition?
The concept of moving to and taking up residence justice, once it is defined, can constitute which Canadians, in fact, do have a colorable claim under 6.2a for being denied entry into Ontario. Whether or not that applies to someone getting a drink of water, again, that would imply whether they in fact took up residence, moved to Ontario to take up residence, which would again depend on the definition.
Okay, but your definition, your class definition doesn't say take up residence. It says who made plans to enter the province of Ontario and canceled them. And that doesn't track any language in section 6.2. It doesn't say take up residence or earn a livelihood. It just says plans to enter.
So this definition may be broad, but it can be broad as long as it's not unnecessarily broad. The Supreme Court of Canada held in Hollick and City of Toronto at paragraph 21, a class definition is not unnecessarily broad if narrowing the definition arbitrarily excludes some people who share the same interests in the resolution of this common issue of 6.2a. Here, some tourists and travelers through Ontario may and likely do have colorable claims for such a 6.2a breach, and narrowing the definition would unnecessarily exclude them.
So these criteria, sorry, you
No,
go,
go ahead.
you go ahead. Okay, so the criteria that my colleague was asking you about, plans to enter and canceled, are those not both highly subjective as compared with what is the paradigm for requirement for a class definition being objective?
No, the concepts of making plans and canceling them is objectively defined and helps class members identify themselves without the merits to this case. Class membership can be easily verified based on proving both the creation of plans to enter Ontario and the cancellation of said plans through correspondences, transaction histories, and through sworn testimony in court.
But sworn testimony can be subjective. You know, I intended, state of mind, isn't it? I intended to do X. And then now some of the, fairness to you, some of the points you raise are objective, i.e. you could, if you have reservations, if you purchase tickets, if you have rented something someplace, there are various objective factors that could have come to bear on this. Those are objective, but the state of mind part of it, I mean, is it not a case of mixed subjective or objective, or am I just confusing myself or you?
The class definition is objective, and this court is more than capable of judging potential class members based on their individual circumstances and based on their individual correspondences, sworn testimony, and transaction histories about whether or not A, plans were in fact made, and B, whether in fact they were canceled due to these travel restrictions. And this really gets to the crux of individual circumstances and individual issues trial, but there is an objective enough character to the class definition to satisfy the Bywater test. If there are no further questions, I will turn briefly to adequate scope. The definition is neither unduly broad nor under-inclusive. The wording "canceled due to travel restrictions" narrows the class to the time period in which charter rights were violated. It's confined to plans that occurred while the travel ban was in place and only captures cancellations made after this announcement. It's further limited by omitting anyone who clearly fits within the exemption order's categorical exemptions after the exemption order was made. But it would include these people if they had
Okay, you
canceled
just have
plans.
1 minute left, so you should be getting ready to wrap up, please.
Yes. And I do see, yes, I'm short on time, so may I ask for a brief indulgence to finish my argument and conclude?
Yeah, you've got 1 minute left, so go ahead.
But this class definition would also include people if they had canceled plans during the 2 weeks when the travel ban order was in place before the exemption order was issued. And finally, the class definition is not unduly narrow for excluding those who chose not to travel to Ontario solely out of fear for the blue lily disease. While there's still may be a colorable claim, this court stated in Dumoulin in Ontario, class definition is perfectly capable of failing to include these people to make the action more manageable. I leave the remainder of my submission on 2 or more persons to paragraph 27. And to conclude, the Rose's pleadings and the proposed class definition set the stage for an action. My colleague will now take you through parts D and E of the CPA 5.1 to substantiate that this action should be certified. Thank you.
Thank you, Mr. Murphy. Go ahead, Mr. Grohe.
Thank you, Chief Justice. Thank you, Justices. At the outset, I just want to address an issue with the class definition. It is difficult to address preferability when there are lingering questions about the class definition. I stand by the able submissions of my colleague, Mr. Murphy, that narrowing the class definition here runs the risk of unfairly excluding class members with legitimate claims. However, if the court is simply not with us, then I would say that the remedy then is an adjournment, peremptory on the plaintiffs to produce a suitable class definition, and that would not prejudice the defendant. It would not create any prejudice that could not be compensated for with costs. Now, onto my submissions. I will be addressing preferability as well as the representative plaintiff. Now, I will contend that there is some basis in fact that the plaintiffs have met the test for preferability in section 5 sub 1 and 5 1.1. I will show that. So I will briefly address superiority. I will show that class action is superior to all the reasonably available methods of determining the entitlement of the class to relief or addressing the impugned conduct of the defendant. In this case, that is the exemption application process, judicial review, a test case, and the case management of individual actions by Rule 5 joinder or Rule 6 consolidation.
I have a question. My question is, what's the difference between superior? What do you think the new amendments mean? Like, because it must mean something. And then what's the applicability of the old law?
the new amendments in our submission, they clarify what it is the plaintiff has to show. So there was always, from AIC Limited and Fisher, we know, and even Hollick and progeny, we know that there is this comparative exercise. We must compare the class action to other procedures that are not necessarily court procedures. They may be remedial programs, recall programs, small claims trust funds. So it's always been the case that there's this limited cost benefit analysis. Now the codification of the superiority requirement simply takes it a step further, step closer to the US Rule 23 framework. However, there has always been this idea that a class action should be the most fair, efficient, manageable method of advancing the claim. That's always been there.
So are you saying that this is just like, it's a whole scale adoption of the US test then?
No, at paragraph 34 of the plaintiff's factum, we have outlined a number of important differences between our frameworks. And particularly, I would only highlight the issue classes, which exist in the Rule 23 framework and which are completely incompatible with the scheme context of the CPA. Now, plaintiffs in the US federal courts, if they do not, so if the entire cause of action, if the common issues, if they do not predominate in the entire cause of action, nonetheless, the consensus view among the US federal appellate courts is that some common issues can be separated and they can be certified as issue classes under Rule 23C4. If within those issue classes, the common issues, common questions of fact or law predominate over individual questions. And I admit, I must be more precise with the language here of common questions as opposed to common issues. And that distinction does not exist in the CPA in the context of these amendments. So for that reason, and as well, there are many other reasons, the higher evidentiary standard, the fact that the US litigants are required to probe behind the pleadings, it makes it that we cannot simply adopt the Rule 23 framework as is into Ontario.
Okay, thank you. Sorry for interrupting you.
Now, briefly, I will say that when it comes to a test case, this is not a test case, this action, if it were an individual action. Neither is that of the daffodils, of which there is an interlocutory judgment in the defendant's motion record. And I don't need the court to turn to it. The facts are somewhat different, although the relief pleaded is the same. Now, the reason I say none of these are test cases is that only a class action would finally bind the defendant to all class members such that the principle of res judicata applies. Whereas,
well, fair enough, but I mean, if there's one case against the government and they find that there's a charter breach, I mean, can't everybody else rely on that? If the legislation is invalid, and isn't it possible that, I mean, could they actually defend the action?
It depends on the facts, the individual circumstances of every class member. Technically, the defendant they have some leeway to argue the inapplicability of any adverse findings, of course, subject to stare decisis. But another important problem with any individual action alternative is that it excludes anyone who cannot afford expensive litigation. That goes for judicial review, that goes for individual actions. That just excludes an entire segment of the class, those with small, meritorious, but economically non-viable claims. Unless there are any, and on the topic just briefly on consolidation and joinder, the plaintiffs have at page at tab 4, tab 5, page PDF, page 50 of the plaintiff's motion record, the plaintiffs have adduced a litigation plan. The defendants have not adduced any plan for case managing what could be tens or potentially, as evidenced from the affidavit of Dr. Marigold in the defendant's motion record, potentially thousands of individual actions. Only the plaintiffs have a plan. Now, the main thrust of my submissions are going to be on the predominance of common questions of fact or law over individual questions. And for this part of my submissions, I would ask that the court turn to the plaintiff's motion record at tab 4. That is PDF page 50. And there, so while the court is turning to it, I'll just describe what the document is. This is the list of preliminary common issues. And I will show that these common issues predominate. And the standard here, we know the standard. Even though there are no decisions from this court or any other court, any appellate court that interpret these new amendments, we know what the standard is for predominance. We know it because of the Supreme Court of Canada's decision of Rumley and British Columbia. It's a case that the facts are very different. The conduct in that case was much more egregious. It was a case about a residential school for deaf and blind children and abuses that occurred there. I'm not submitting the case for that reason, but at paragraph 36 of that case, the court examines predominance. And because this case arose in British Columbia, British Columbia's statute, class action statute, does have a non-mandatory predominance requirement. So the court was forced to consider.
Did you say a non-mandatory requirement of predominance? What does that mean?
Predominance is
No, the non-mandatory part. What do you mean by that? Like what's a non-mandatory predominance?
So there is in the statute, in the relevant provision, there's a enumerated list of factors that the court must consider, and chief among them is predominance of common questions over individual questions. However, it is not determinative. And
I see.
So it is not like our provision, which mandates that be the case. However, it's still the case that the jurisprudence from British Columbia is still highly instructive. And so in Rumley, at paragraph 36, the court examines how the plaintiffs framed their issue. So they framed their issue in systemic negligence. And then the court there said that while there were significant issues of injury and causation, and these were individual issues that had to be litigated in individual trials, nonetheless, they were a relatively minor aspect of the case. And so from that language, we can determine that the standard is qualitative, not quantitative. So it's not the case that we count the number of common issues and then we compare that. So it's not the numerosity of common or individual issues. A single significant common issue that moves the action a significant way can predominate over numerous individual issues. And the fact that it was qualitative, not quantitative, that was confirmed by the Court of Appeal for Ontario in Cloud and Attorney General of Canada. And again, facts were very different. It was a residential school case. The state conduct was much more egregious. However, I only submit the case for the principle, for the standard that I say that the plaintiffs must meet. Here,
is the Supreme Court of Canada decision in Rumley where they talk about the meaning of predominance? Is what they say different than what they say in the US? Because I think they've got the same criteria in the US, right? That it's got to predominate?
they do.
And how do they interpret it?
In our factum, we cited Professor Rubenstein. I don't have specific judicial authorities to point to. Well, we did cite the case of Comcast and Barron, and the majority decision there was somewhat, the court did say that the matter turned on established principles, but that was an antitrust violation case. It was really about, the court decertified a case because the plaintiff's theory of antitrust violation did not directly link to their methodology for estimating aggregate damages. It was a very unusual case in that the dissent there said that it remains the black letter law that the presence of individual issues, and particularly individual damages issues, does not automatically preclude certification, even under Rule 23b3. And Professor Rubenstein, whose treatise on class action we cited in our factum, also confirms that it is a qualitative, not quantitative standard. Unless there are any questions, I turn to the issues in this case. So the proposed common issues are that, first, in implementing the travel restrictions, did the defendant breach class members' rights under Section 6, Sub 2 of the Charter? So here the focus is on the conduct of the defendant. I understand that my friends submitted in their factum that there is this need for individualized inquiry. So the problem is, they say that, or I understand them to say that the Section 6.2 can be violated in a myriad, in infinite number of ways, and that requires substantial individualized inquiry. That's not the case. And even where individualized inquiry is required, that can be elicited. So that evidence can be elicited by the claims administration process, which the plaintiffs put forward in their litigation plan. And that's at the plaintiffs.
I'm sorry, Mr. Gurry. Isn't the real problem that if we're asking whether the defendant breached class members' rights, I mean, I understand your argument that focusing on the emergency orders focuses on the defendant's actions, but when we talk about class member rights, we then get into what is the scope of the right. And that is a question that can really only, I think, be illuminated by looking at individual plaintiff circumstances. So, your clients are in one position. Somebody who lived in Gatineau and wanted to drive to Ottawa for dinner might be in a different position. Someone who wanted to come for a week, to Kenora from Winnipeg and was going to drive and stay with their mom might be in a different position. So does that not bring an individual aspect to what you're saying is a common issue?
Although the individual circumstances will vary infinitely, there are categories or that could properly be subclasses, although I know that the Roses have not pled any subclasses, but that problem could potentially be addressed by the creation of subclasses that would cover the most common, the categories that would basically cover most of the circumstances. So you could have, for example, the Roses could be part of a subclass that consists of seasonal owner, dweller, business operators. And then you wouldn't need all of that individual inquiry,
But wouldn't those be so idiosyncratic that almost every iteration of it would be a separate subclass? Because they're all going to be different. I mean, I don't know how you would put a circle around them and call them subclasses. They'd be a subclass per individual almost. Wouldn't they? I mean, I think then you run into this subjective thing. I don't know. This is pretty problematic, isn't it? I mean, how do you thread your way through this argument that my colleague's making? She's kind of difficult that way. I get this feeling.
Thank you, Chief Justice. One way of addressing this issue is through the the expansive and generous jurisdiction under Section 25 of the CPA, and that allows the court to craft a comprehensive plan for addressing issues following the common issues trial. Now, that doesn't necessarily, I guess the concern here is that it's going to the class action is going to devolve into a multiplicity of individual trials. And that doesn't have to be the case. So the claims can be organized as to complexity, dollar value. There can be simplified procedures for the less complex cases.
But that's all fine. That's all fine. You're in the vast majority of class actions. There are individual issues, and so that's not a problem. The problem here is with this amended statute, you've got your superiority predominate problem that's been adverted to earlier, in which case you have to show, I don't know how you compare it to Anderson and Wilson, and you were alluding to this earlier, but you have to show not on a numerical aspect, but in a significant way, the predomination of that is created by the common issues in moving this litigation forward, right? And that's what they were talking about in Anderson and Wilson. So the question my colleague put you, is that law applicable anymore? I don't know whether it is or not. But that's a kind of a threshold question. But the issue nonetheless is basically the same. The only thing is the criteria that determine it are varied now, right? The issue is the same. How far does the common issue move it forward, right? In terms of getting it closer to judgment day. Is that a fair statement or not?
Yes. So the proposed common issues. So if we start with the first one, the existence of a breach of 6.2, we say that moves the action far enough along that the remaining individual questions simply pale in comparison. The action has progressed to a point where any individual issues are just of such minor importance that it can be said, even if only one of the common issues is certified and is found, it can be found to predominate over numerous individual issues, given the standard from the case law. And I see that I'm running short on time. May I please ask the court for an indulgence just to briefly conclude and answer any remaining questions?
Yeah, wrap it up, please.
Thank you.
Be quick though, because there's a penalty for going over time. We don't impose it usually, but it is one. It's not superior, and it doesn't predominate over fairness.
Thank you, Chief Justice. Here, the plaintiffs have met the requirements of Section 5.1. I know the court has concerns about the class definition, but that can be amended with leave of the court without prejudicing the defendant, that's not compensable by costs. And the few common issues predominate over any remaining individual issues. For the balance of my submissions on representative plaintiff, I commend to the panel the plaintiff's facta at paragraphs 40 to 42. Thank you. Those are the plaintiff's submissions.
Thank you very much, Mr. Grohe. That concludes then the moving party's argument, except for reply. So could we hear now from the respondent, please?
Good afternoon, Justices. My name is Maya Coe-Parker, and I, along with my co-counsel Dylan McIsaac, appear on behalf of Her Majesty the Queen in right of the province of Ontario. In these times, we know all too well the toll that a global pandemic can take on our communities. The residents of this province have entrusted us to deploy all the resources we can to keep them safe in response to this unprecedented public health emergency. Our administration prudently implemented a travel ban order with a corresponding exemption process. This approach safeguarded the well-being of Ontarians and balanced people's urgent personal considerations, as it allowed almost 1,000 non-residents to enter the province in the first 3 months of the regulations. 2 of these non-residents allowed entry into the province are the proposed representative plaintiffs in this motion. Despite this, they allege that our government's efforts to secure the health and safety of our residents violated their ability to enter the province in order to take up residence and gain a livelihood, and similarly affected an entire class across the country. However, their claim does not satisfy 4 of the 5 certification criteria under Section 5, subsection 1 of the Class Proceedings Act. First, I will submit that the plaintiffs have not pleaded a viable cause of action under Section 5(1)(a) of the Class Proceedings Act. Second, I will submit that the class definition proposed by the plaintiffs does not meet the requirements under Section 5(1)(b) of the Class Proceedings Act. My co-counsel will address the requisite Section 5(1)(d) and 5(1)(e) criteria, and the criteria under Section 5(1)(c) are not at issue. Turning to my first submission, the plaintiff's pleadings do not disclose a valid cause of action. These arguments begin at paragraph 10 of the province's factum. The facts contained in the plaintiff's pleadings do not rise to the level of demonstrating breaches of Section 6(2)(a) or 6(2)(b), nor do they support a remedy for charter damages under Section 24(1). To engage in this analysis, the court must look within the 4 corners of the plaintiff's statement of claim and consider the viability of their claims based on those facts pleaded. At paragraphs 18 and 22 of the plaintiff's statement of claim, the plaintiffs plead breaches of Section 6(2) and attempt to justify damages under Section 24(1) of the Charter. However, there are no facts contained within these pleadings that support the statements in these paragraphs. As the Ontario Court of Appeal noted in Wright and Horizon's ETFS management, allegations that amount to bald, conclusory statements which aren't supported by material facts may be fatal to pleadings. The statement of claim does not mention any facts that demonstrate that the plaintiff's intention was to travel to Ontario for the purpose of taking up residence, as per Section 6(2)(a) of the Charter. At paragraph 9, it notes that at all material times, they were in fact residents of the province of Quebec. It also does not plead any facts that, if proven true, demonstrate their ability to gain a livelihood was infringed while they remained outside the province.
But can't we, I mean, okay, they didn't say that they came here to take up residence. That could be a slip in drafting. Can't we give leave to amend?
So, Justice, I would answer your question in 2 parts. The first being that this is an important consideration to make, the fact that these pleadings don't make out material facts to support this cause of action. In fact, former Chief Justice McLaughlin in the Queen and Imperial Tobacco said that it is incumbent upon the claimant to clearly plead the facts upon which it relies in making its claim. The facts pleaded are the firm basis upon which the possibility of success of the claim must be evaluated. If they're not pleaded, this exercise cannot be properly conducted. So we say that the court should give importance to the fact that these pleadings are deficient, but we also say that even if the pleadings were amended to contain these material facts, this motion still fails under Sections 5(1)(b), D, and E of the Class Proceedings Act. The plaintiff's pleadings also do not disclose a remedy and damages pursuant to Section 24(1) of the Charter. As established by the court in Kohler and Newfoundland, pleadings for charter damages should articulate material facts that, if proven true, demonstrate the province deliberately violated the plaintiff's charter rights and underpin a finding that damages would be an appropriate or just remedy. Again, the statement of claim simply provides bald, conclusory statements about the province's conduct being deliberate, willful, and reckless at paragraph 22, but does not state any—
The province didn't accidentally make its emergency order. Like, how do we ascribe, or what kind of meaning do we ascribe to deliberate in that context?
So in this context, the facts pleaded do not state that the advisory board explicitly told the government that restrictions on travel or the legislation that was authorizing them were blatantly unconstitutional, and that the government recklessly proceeded with this in mind. So we say that the material facts pleaded here do not rise to the level of making out a deliberate, willful, and reckless action by the government.
So do you say that to be deliberate for this purpose, that the government had to intend to breach the Section 6 rights?
So we say that any consideration about the government's intentions or actions is something that should be saved for a merits trial. But in this case, when we look to the pleadings and we look to paragraph 5, the statement of claim notes that in February 2021, the advisory board suggested that restrictions on travel were unnecessary at the time and noted that there were constitutional considerations at play. Now we say these facts don't rise to the level of showing any sort of deliberate, reckless conduct on the government's part.
Okay, so, but you're telling me what deliberate isn't. I'm asking you to tell me what deliberate would be.
So in this case, we say that deliberate would be if the government were explicitly advised that what they were doing was unconstitutional, or that the legislation that they operated under in order to implement these travel restrictions was unconstitutional. And they were put on notice of that and proceeded in the face of that. So we say that's something that would rise to the level of being deliberate, which isn't contained in pleadings.
Okay, thank you.
Well, I'm just going to pick up on what Justice Akbarali said. So that kind of means, I mean, what you're saying suggests that you could never prove a charter breach unless the government turned its mind to whether there was a possible charter breach and then proceeded in any event. And I don't think that that's the law. I think that there can be deliberate conduct, meaning just you meant to do the thing and then it happens to violate the charter. I mean, I might be wrong. I mean, I'm just asking you.
Justice, again, here we rely on the interpretation of how to disclose a remedy in charter damages from Kohler and Newfoundland. And in this case, the claim is a breach of sections 6(2)A and B, and there should be a necessary remedy in charter damages. And what needs to be in the statement of claim here is that facts that, if proven true, show that the province deliberately violated those rights. So again, we say if those facts were made out in these pleadings, that could be the case, but here that's not the situation. Turning to my second submission, the plaintiff's proposed class definition does not satisfy the conditions under section 5(1)B of the Class Proceedings Act. These arguments begin at paragraph 21 of the province's factum. The plaintiff's proposed class definition includes all Canadian citizens and/or permanent residents living outside Ontario who made plans to travel to the province but canceled them due to travel restrictions. The proposed definition is subjective, imprecise, and overbroad. The issue that strikes at the very core of this class definition is that the requirement of a plan to travel to the province means inclusion in the class is predicated on proof of state of mind or the subjective intentions of potential class members. Courts have consistently held that class definitions cannot depend on such factors, and for good reason. This proposed definition creates a situation where potential class members will have to prove their way into the class. This goes against the very purpose of creating an objective class definition, which is necessary so that any given person can determine whether or not they're part of the potential class by looking at this definition, as stated by the Supreme Court in Hollick in the City of Toronto. This was most recently illustrated in the decision in Kohler and Newfoundland, which bears similar facts and a similar class definition to the case at bar. And there, the court rejected class definitions requiring intent to enter the province and a demonstrable plan to enter the province, because inclusion in the class was dependent on proof of intention or plan. The lack of precision in this class definition further augments the issue of subjectivity, as it leaves a number of questions about who exactly gets included in this class. The class definition does not define what is meant by the terms plans, cancellations, or due to travel restrictions, and does not set any temporal limits to the class.
So your friends were suggesting that if we find the class definition to be imprecise or vague or overbroad, that they would like an adjournment to, propose a different definition of the class. And class definitions are often sort of technical as opposed to substantive. So what do you say about that?
So, Justice, we say that the plaintiffs have not come here presenting an alternative class definition. With this class definition we have here, there are a number of issues with it regarding its precision and also with its overbreadth. And some of those amendments that they may come up with might get into further issues with their class proceeding as a whole. And I can go to my arguments about overbreadth just to explain what that means. So first, the class definition doesn't distinguish between a delayed plan and a canceled plan. So it doesn't limit the class to those who applied for an exemption and were denied and precluded any sort of entry into the province. And this means the definition includes people like the Roses, who may have delayed their plans to enter temporarily until their exemption request was granted, and including people who were technically never denied entry into the province means they may not have a relevant interest in the resolution of common issues. Second, we also say that the class definition is so broad that it includes identifiable groups of people that Plaintiffs' Counsel has been in contact with, such as bird watchers, wedding guests, and protesters, who may not have any claims under sections 62A or B of the Charter, because they were traveling for leisure and not for the purpose of taking up residence or gaining a livelihood. Now, class definitions aren't required to only include people who would have successful claims, but they should not be so broad as to include identifiable groups of people who would have no claim at all, as is the case here.
So I guess trying to summarize what you're saying, I hear you saying, taking a long way around, that first of all, because it's impossible to determine from their class who they really intend to include. And so it would be impossible to come up with an alternative definition. Is that what you're saying?
That's correct, Justice.
One of the goals, though, behind the Class Proceedings Act is access to justice. What is the harm in giving them an adjournment to try?
So, Justice, we say that this situation, from the pleadings to the litigation plan and the issues with preferable procedure and the representative plaintiff as a whole, create a class situation that may not be in the best interest of access to justice, because there are so many overarching considerations that the court will have to take into account. So we recognize that class members definitely have an interest in accessing justice, but this class proceeding is not the avenue for that.
So what is?
My co-counsel will actually address those parts in the preferable procedure submissions under section 51D.
Okay.
I did also want to add that the lack of precision in this class definition further augments this issue of subjectivity, because it is unclear exactly what constitutes plans and cancellations for the purposes of inclusion. We don't have any parameters identifying what it means to make a plan or to have canceled said plan under this definition. So it's anyone's guess whether this means potential class members would have to have already made travel and accommodation arrangements, whether they were in the process of doing so, or whether they briefly discussed going to Ontario during that period of time. It's also not clear whether the people who voluntarily canceled plans while the travel ban order was in effect fit in under the current requirement of cancellation due to travel restrictions. The Toronto Telegraph reported on people who proactively canceled their plans because of the growing public health threat, and they may not know if they're part of the class because of this definition. Further, there is no specific time period in which plans and cancellations were to occur to be included in the class. The definition refers to travel restrictions generally, but doesn't indicate a specific start and end date. And this is problematic when considering there may have been people who canceled their plans before exemption criteria were identified, and it's unclear whether or not they fall into the class with this definition. Justices, we say the plaintiffs have not met their onus of demonstrating that this class definition meets the requirements under section 51B. This class definition includes people with a multitude of issues and grievances, which my co-counsel will argue presents the court with further problems under section 51D of the Class Proceedings Act. It also includes people like the Roses, whose own charter claim may not be sustainable since they were allowed to enter the province, which my co-counsel will elaborate on when discussing issues under section 51B. With this, the province submits that the plaintiffs have not met the certification criteria under sections 51A or 51B of the Class Proceedings Act. My co-counsel will now address the requisite certification criteria. Unless I may be of any further assistance to this court, these are my submissions. Thank you.
Thank you, Ms. Coparker. Go ahead, Mr. McIsaac.
Thank you. Good afternoon, Chief Justice, Justices. My name is Dylan McIsaac, and the province of Ontario has two further submissions. The province submits that pursuant to section 5.1D and 5.1.1, a class action is not the preferable procedure for the proposed claim. The second submission is that the representative plaintiffs do not meet the statutory requirement under section 5.1E. So beginning with preferable procedure, there are three key points I will address, and the relevant paragraphs of the defendant's factum are from 34 to 46. First, the amended Class Proceeding Act and section 5.1.1 alters the preferable procedure common law test. Second, the common issues do not predominate the individual issues. And finally, a class action has not been shown to be superior to reasonable alternatives. Justices, you are aware that in the year 2020, in the midst of a global pandemic, the provincial legislature passed important changes to the outdated and inefficient Class Proceedings Act. When those changes were made, the stated purpose was to stop burdensome and expensive class actions which cannot be resolved in a reasonable amount of time.
Well, I mean, are you telling me that all of the class actions that have been brought to date under the old legislation have been a mess and if there's been an inability to address them because of the way the statute was worded? Has that been demonstrably proven?
Justice, I was just simply pointing to the comments by the Attorney General, Doug Downey, when presenting the amendments to the CPA to the provincial legislature. And he stated that certification was in need of a rebalancing.
What difference does it matter? What difference does it make? I mean, why don't we just get on with the argument about what it says? We don't care why they did it, really. They did it, so now we're stuck with the statute. Let's just delve into that and get down to it.
Well, we would say that this proposed class action brought during a new and evolving health emergency would not meet those former certification criteria nor the standard yet. So I'll move right along and I'll say my friend's submissions speak to the two-branch common law test for preferable procedure from Fisher and the province of Ontario submits that this test has been significantly altered by the amendments. We say that section 5.1.1 now demands greater scrutiny to both branches of that test, and that superiority and predominance are additions to the Act specifically aimed at enhancing the rigors of certification. So we state that where before the analysis under section 5.1D asked if a class action were preferable for the resolution of the common issues, the new Act under section 5.1 expands that breadth of the analysis. It asks if a class action is superior to all reasonable means of determining both the entitlement of the class and for addressing the impugn conduct of the defendant. And we state that this new language in the Act brings Ontario's class proceeding regime closer to the American model, which uses the same requirements.
So how does it apply to the facts of this case so we can get to that before your time runs out?
Okay, I'll move right along to the preferability requirement, which is addressed at paragraph 36 to 41 of the defendant's factum. So we say that this proposed action includes a potentially massive class of citizens spread across the country, each with their own individual travel plans. The province of Ontario, when instituting the travel order, created an application process in order to consider each exemption request they received individually. The Office of the Chief Medical Officer could assess every application based on its own particular merits. We state that this proposed class action would attempt to collectively assess each of these individualized decisions and the personal considerations of every class member from across the country, and that this would inevitably devolve into a mess of complexity and cost. And looking at the problem first in terms of size, the proposed class is immediately severable between those members who claim a section 6.2a breach who are simply trying to reside in the province, and those who claim a section 6a and b breach, alleging they have some business or financial commitment in the province. These are two distinct groups which immediately cut the class in two in terms of what significant individual issues a court would have to assess. And we state that even those subclasses would not present a manageable class because each charter claim is individual based on the intentions and actions of that particular claimant. We point to in our factum the Court of Appeal decision in Thorburn in British Columbia, which speaks to how charter rights are individual in nature. And there the court denied a proposed class action where that alleged charter breach would be, quote, dependent on a multitude of variable circumstances unique to each class member. And I note that Thorburn has been applied recently in our Court of Appeal and a decision last year called Cirillo in Ontario. And in that case, the reasonableness of that alleged charter breach were found to be not capable of common determination because of the amount of individual questions.
Well, what about Brazo and Reddock? That's got to be that's got to be way more complicated individual issues, right?
Well,
Those are the solitary confinement cases.
Yes, Justice. And we would distinguish it on the same way our friends distinguished the Rumley case that he brought up, in that these are cases that deal with Section 7, Section 15 of the Charter, more generalized charter rights than the individual nature of, say, a Section 6 breach or a Section 8 breach, which was in Thorburn. And we'd say that Rumley and those types of cases are looking at systemic negligence, which is much different than the issue at hand here. A finding of systemic negligence leaves only that determination of what damages are issued after that point. A breach of Section 6 still involves quite a bulk of analysis of determining the extent of that breach, for which reasons the breach happened, and whether that breach can be reasonably justified. So, yeah. And we state, I'll list for your information, Justices, that there are many different issues that need to be determined. There's issues like why the class member may have wished to enter the province, when was their attempt to enter the province, whether they applied for an exemption, when did they apply for an exemption. And that's just a short list, but it doesn't even get into the Section 6.2b questions about how one might be pursuing a livelihood, which comes with a whole host of other determinations. And we say trying to assess each of these determinations together overwhelms any decision on the common question, which is submitted by the plaintiffs.
Well, your friend says that the main issue is you've got to find one or a couple of proposed common issues that qualitatively predominate, and you can have many individual, like the things that you've mentioned just now, they're individual issues, but they're not big issues really. And so what they're saying is the main issue here is whether there's a charter breach, the whatever the legislation is, and that everything out, and that predominates over everything.
Well, Justice, I'd look to Hollick, and there's Chief Justice McLaughlin found that even a finding of fact in that case of a landfill that was spewing out pollution, which affected all of the class members, wouldn't be a common issue which advanced the claim in a significant manner, because the individual issues, just of the degree of which the person was affected by that pollution and what time they may have suffered from that pollution, was the bulk of the analysis. And she found that the common issue, which was necessary to each claim, was still negligible in comparison to those individual issues which would have to be determined. And I'd even point to the learned exemplary Justice Winkler in Moteras and DeVry College. And he spoke of the experience of the class members in that were idiosyncratic and based on the motivations of that student class. And the numerous variables that was true to each class member overwhelmed that common issue. And that was before the new amendments to the Class Proceedings Act. So I'll move now to the comparative branch of the defendant's factum, which is spoken to at paragraph 42. So section 5.1.1a now requires a class action to be the superior method of resolving the claim. There are now enumerated alternatives in the act that the plaintiff must address. Namely, the onus is on the plaintiff to show that a class action is superior to quasi-judicial administrative proceedings, case managements, and any remedial scheme outside of a proceeding. And aside from that statutory onus on the plaintiff, we state that there are specific alternatives that the plaintiffs have not shown the class action to be superior to. First, we submit that a test case would better determine the constitutionality of the travel ban. And second, we
square with the argument you just made, because you just told us there's so many individual issues, and now you're saying, but we can do a test case. How can we do a test case if so much of it is driven by individual issues?
Well, Justice, we'd say that this is a class action destined to devolve in the determination of individual issues. So utilizing a test case to determine that central common question that the plaintiffs have put forward on the Section 6.2 breach would forego the long and drawn out procedure that is a class proceeding. If this action were to be certified, then we would have to wait out an opt-out period. We would be addressing other pretrial motions. We could have a hearing for summary judgment or as another hearing like this. And we say these court resources could be saved by denying this motion or staying this motion and waiting to see what the determination in Daffodil is, and then perhaps bring another action if there is to be found a Section 6.2 breach.
Are you prepared to consent to be bound by the decision in Daffodil in any other case?
Well, Justice, that's not the question here under a certification criteria, especially under the new amendments. It's the onus of the plaintiff, and it's not the defendant's onus, it's not your onus, Justice, to determine what is the superior method to proceed with. And we state that the plaintiffs have not shown that this more direct and judicially efficient method has not been shown to be less than superior.
Okay.
And I'd also emphasize that the Attorney General, when amending the CPA, stated that test cases remain underutilized tools to resolve matters. And the Daffodil action was filed prior to the plaintiff's claim, is further along in its litigation, and that's.
But it's kind of cute to say we can do a test case without saying we agree that Daffodil's a test case.
Well, Justice, I'm not sure how, if a test case was agreed to before this procedure, then I don't think we'd be here today. I believe that we'd have moved in that direction already. It's the plaintiff's onus to show.
I understand that, but there's a practical side to things too. That's
Well,
my only point.
Well, yes, I understand, Justice, and we'd simply say that it's test cases are something that's been brought up since Hollick and stated that it's a viable alternative. And to address it in a certification is something that the plaintiffs have to address, or they have not met their onus under superiority. And I'll move to considering some of the other alternatives. And I'd say it's important to emphasize again the central difference between the Roses claim, which includes a Section 6.2b breach, and the majority of the class who has no claim related to pursuing a livelihood. We state that this proposed action on its face is unmanageable and provides no contemplation on how many individual issues could possibly be efficiently handled if this class proceeding would be.
Daffodil didn't have a claim for damages in that respect, did it? Or not?
No, sorry, I was moving on past the.
No, I know. I just asked you a question.
Oh, sorry, Chief Justice. No,
it's a follow-up question on my colleague's question.
Sorry.
Was Daffodil on four squares with Rose? It goes to whether or not one could be a test case for the other. If they're not the same, it couldn't be, right? If they are the same, it could be.
Well, we say
that's what she's kind of giving you with a shaft for there, is dodging her question, called dodgeball.
I'm certainly not dodging just the Chief Justice.
No,
I
didn't. I just said it looked like it, but it may not be. It's like we'd have to have a common issue trial to find out, or an individual issue trial. See if you intended to deliberately avert her question.
Justice, I would say that it speaks to the central issue of this plaintiff's claim. It's not the same issue. The Daffodils, we admit, do not have the exact same motivations as the Roses, and we say that also speaks to the fact of how many different individual issues have to be assessed across this class with many different motivations and impacts. And we'd say that no, it does not come to an issue on the damages, but utilizing the Daffodil action to make a finding on that central issue and allowing the class to use the precedential.
So let me ask you this: so just sum up this for me. What do you say what other procedure? The problem I always have is to come out this different direction is that the responding counsel invariably say that the class proceeding should not be proceeded with because there's some other mysterious thing out there that the plaintiff should be doing. And then when you finally add and subtract everything they say, they basically say they shouldn't do anything. Is that what you're saying? That they shouldn't do anything? Their alternative is to do nothing?
That's not our submission.
What do you say? So then my follow-up is, what do you say they should do then? You say they shouldn't be allowed to bring the class proceeding, but they shouldn't have to give up their lawsuit either, should they? Their choice isn't to give up their lawsuit. You're not saying that.
No, Justice.
No. So what it is it then? You're not supposed to give it up. What should they do?
Justice, we say that this is a class action, and I'll get to it in my next submission as well, of the many issues with.
Time is running out, so nail this one fast, because I'll forget what I asked you soon if you don't answer.
Justice, we'd say that an action that like this, that has so many overwhelming individual issues, that's destined to devolve into the determination of individual issues, can't be said to be superior.
Okay, but that's not my question. My question is, if this doesn't work, and that's where I started with the assumption, accepting your argument that the preferable procedure rules this out. So what do you say if they can't have a class proceeding? What should they do? Don't deal with why they can't win this one, because my question is based on the premise that they can't do this one. What should they do aside from nothing? Nothing's not an option to me.
Justice, we wouldn't say nothing. We would say there's a hypothetical class action out there with defined causes of action, with a workable.
Well, I never asked you that question. I'm just coming back, same question until I get an answer. I'm just kind of like a dog with a bone. I'm just going to keep coming back. So assume that that you're right, class proceeding is out because of the new pref procedure test. Okay, assume that for the sake of the question. Secondly, assume that it's not an option that they do nothing. Okay, so that leaves a third option. What should they do? That's my question. So if the pref procedure's out and doing nothing's out, that leaves only one other option. What else can they do? Is the answer to that nothing, or do you have a suggestion?
Justice, our submission is not that a class action is impossible. This class, or a more narrow class.
Well, be careful about going down that path, because we'll get you certified as fast as you can blink an eye. And then your attorney general, who doesn't like the statute, is going to be unhappy with the result.
Our submission is that there are plenty of issues from section 5.1a, b, d, e that makes this class action uncertifiable. But our submission has never been that a section 6.2 class action is impossible. We just simply say that this one is unmanageable in the way that it is submitted by plaintiffs. So you're asking what other options? We say that there are plenty of options that could be viable, but this class action presented by the plaintiffs is not.
Oh, okay.
So
okay, so you better get on to your rep plaintiff then, because you got short time. You better nail that one quickly.
Okay, we'd say that we're aware that the finding the best possible class representative is not the section 5.1 standard. But however, as my co-counsel referred to, the Roses claimed that they had plans to enter the province, that they were denied, but then they eventually were allowed it. And this is the same as the representative plaintiff issue as was in Kohler. And we state that this class definition does not provide parameters to determine whether the Roses experience even constitutes a cancellation. We've had some discussion on this, and we find that it's debatable whether the Roses themselves fall in with that class definition, seen as they eventually were allowed. And as such,
but they didn't get in there early enough, right? They ended up losing their biggest business season when the fact they didn't get in and couldn't get the in ready until the mating season of the gull was done.
They missed the whole drama. Like the whole thing they wanted to come for was to see those golden gulls, and then all of a sudden the romance was over and they were gone off to fishing or something, whatever gulls do when they're not amorous.
Justice, we would say
it was
that
all history by then. Like was.
I was simply speaking to the fact that the class definition is overbroad and perhaps does not properly fit in the representative plaintiff. And an issue like that, whether it's debatable whether they fit into their own class definition, makes them unsuitable. But aside from that issue, I'd point to the deficiencies throughout the plaintiff's motion, which should bar managing this action. You're aware, Justice, that litigation plans alone do not derail certification motions. However, the errors in omission in this plaintiff's litigation plan do not inspire confidence in their ability to manage this litigation. There's only a 10-day opt-out period. There's only notice for provided in one local newspaper, so a low requirement. Litigation plans are fairly standardized. So such a sparse litigation plan such as this is concerning, and it's indicative of the other issues with the suitability of the representative plaintiff. And we say that issue in concert with issues in the other plaintiff's pleadings, their causes of action, the ill-defined class definition, show how ill-equipped the representative plaintiffs have been in managing the motion at this point. So I'll move to my conclusion now, Justice, and we'll rely on the rest of our factum from paragraph 47.
Okay. Okay, wrap it up.
So I'll leave your honors with some overarching considerations from our submissions. First, that the travel ban was a reaction to a serious and evolving public health emergency. Ontario was by no means the only government which instituted these restrictive measures. Justice, I see my time is up, but I just have a brief moment to conclude this.
Yeah, go ahead, because time's rolling.
And we'd say that this does not reflect reckless overreach. Second, there is a new class proceeding regime in the province, which was enacted for the stated purpose of enhancing the rigors of certification and stopping ill-formed class actions such as this from burdening the courts. And third, that the plaintiff's proposed action outlined from their statement of claim to their pleadings is replete with significant deficiencies, which would lead to an unmanageable action. And for these reasons, we ask the court to deny this motion, and barring any questions, those are the province of Ontario submissions.
Thank you very much, Mr. McIsaac. Okay, we'll call now upon the moving party for reply. Go ahead, Mr. Murphy.
Thank you, Chief Justice. We have just one thing to say in response to our friends' submissions. So I understand our friends to argue under part of their cause of action analysis that the Roses pleadings disclose they are residents of Quebec. However, it is important to note that resident is clearly made in a different context from the Charter Section 6.2 right here. This is an administrative designation with respect to provincial government identification. It is not in the context of the right held sacred in our charter to move to and take up residence in any province. This is crucial to remember for the 5.1a analysis because the pleading simply must not be plain and obvious that the Roses Charter 6.2a claim would fail. This concludes our response. Thank you.
Thank you very much. So we'll retire now and deliberate and come back to you with our comments, and then the results will be conveyed to you at a later time in the conclusory part of the program. So we'll go to our breakout room now, if we may.
So Chief Justice Winkler, just before we do that, if the final round mooters are comfortable, if they could turn on their cameras for a brief moment, and we could take a quick screenshot for the moot and you share on social media.
Oh, perfect.
Okay. So if I'm just taking the cue from our coordinators here, and they will be ready to go in just a moment.
Thank you.
Okay. So if you can want to go ahead and smile, we will take it now. And we are all set. So yes, judges, you'll be moved into a breakout room. Mooters, you can stay in the main room, and we'll be back in approximately 15 to 20 minutes. Thank you so much.
Thank you. Are we live now? Are we all set?
We are live, so they're here for your feedback whenever you're ready to go, Chief Justice Winkler.
Perfect. Thank you, Jesse. Well,
The
thank you.
finalists, if you want to turn your cameras on for this.
Yeah, that would be good. Thank you very much. Okay, well, welcome back on the screen with us, and each of us is going to have some remarks for you, and but I'm going to lead off. I'm going to be big picture, and then my two colleagues will do whatever it is that they think is appropriate and that they want to say. But let me just lead off by saying what a treat it is every year, and this year is no exception, to really see some excellent advocacy. And we, all three of us, until I'm now hearing arbitrations and mediations for the last 8 years, before that, over 20 years on the bench, and my two colleagues are on the bench currently. And, so we're used to hearing lawyers and at every level. And we, I'm speaking now on behalf of all of us, but we just thought that each and every one of you would in a court circumstance, excel, and you would definitely be mistaken for a lawyer called to the bar with a number of years under your belts, because your performances were stellar. They were really excellent. You have composure. You're able to think in your feet. You're articulate. You've got the legal lingo at your fingertips, which is really the key, to think and talk like a lawyer. I always used to say to my law clerks, the thing that you have to get out of this, there's a sort of a crossing the bar here, to use the language out of the old poem, and that's where you start to talk and think like a lawyer. And I used to say this to my law students when I was in practice, that there's really a point where you're working closely with somebody when you see somebody start to think like a lawyer. There's definitely a distinction there that before this, it's like, once I thought as a boy, now I think as a man, there's a line there where all of a sudden something starts to make a difference and things start to click. And all four of you have crossed that line. You're all thinking and you're speaking, and you've got control of the lawyer's language, and and you're indicating to us through your articulation and through your advocacy that not only do you speak with the lawyer's lingo, but you think like a lawyer. And this is, lots of people never get that. Lots of people never achieve that in their whole career, and all four of you have achieved that now, as law students. And so that you've got careers in front of you where sky is the limit. You can, all four of you, achieve whatever it is you set your goal on, as your goal. Sky's the limit. And just as somebody said to me, keep your nose clean and you got a good career in front of you. And so I say that to you. I just make one point, and I don't want any of you to take this, but I remember as a 4 or 5 year lawyer, and I was appearing in front of an American adjudicator, and who I appeared before quite often, so he knew me, and and I was a young lawyer. And I remember one time he asked me a question, and I said, well, I'm going to get to that further along in my argument. And he said, now I see somebody grinning there. See, I know Dylan's grinning, smiling a little bit here, but anyway, so I'm going to get that a little further along in my argument, And he said, Warren, I want to tell you something. If you're going to get to that later on in your argument, I might not care about it anymore then. So I said, Mr. Arbitrator, I've just changed my mind. I think I'm going to deal with your question now as opposed to later on my argument. And he started laughing and he said, good advice to yourself. You see, so I mean, that's just something to stick in your quiver, for years down the road, that there's a hot time hot time to answer a question and you might want a minute to think about it. But you know what? There's immediacy is always important. Why? Because, you know, it looks like you're prepared. And why? Because the advice that person gave me was spot on, that maybe have his mind made up by then, you see. And then my answer wouldn't matter, right? If he's made the decision, because don't forget, adjudicators are thinking, you're advocating and adjudicators are thinking, right? You're doing different jobs at the same time. You're talking and they're thinking, right? And when they're thinking, they're incrementally getting to, they don't make a decision at the end. They're making it minute by minute as they go along, like slicing bread with a knife, and you're going to slice the whole loaf, like my son-in-law is going to slice the whole loaf. If we're going to eat it or not, he's slicing it all. See, that's what judges are like. So they're thinking along and they're coming to a decision. So if you postpone the answer, they may have made up their mind, in which case your answer doesn't matter, right? So that's all I say to you. Now, again, just to conclude, and then I'll hand the floor over to my two pals. You know, what a wonderful job. What a treat it is. You know, I look forward to this every year, and I look forward to it all day when I'm reading the material and stuff like that. And the only real shame here is that all four of you can't win this. You know, and it breaks my heart to see that. I feel badly for days after that everybody can't win. It's just too bad you can't, but that's the problem we have. But, you know, once again, what a wonderful job. What a treat. The pleasure is all ours. And, you know, you've just done a job that you can be hugely proud of. And we're highly honored to be able to come here and see you do your thing and do it with such splendor and give us such joy in having the pleasure of hearing you do your work. So thank you so much.
All right. I'm going, oh, I froze. Okay, I'm back. I'm going to make some general comments and then maybe give a couple comments to each of you individually. Overall, I thought you all did a really good job with things like your voice, your pace. It was easy to follow what you were saying. Nobody had any mannerisms that are distracting. So all of you presented very well. You spoke clearly. So that's all really important, and that can be tough. It can, you know, when you get nervous, and especially when you're running out of time, you can kind of try and pick up speed, and then, you know, we get lost trying to keep up and get hand cramps and stuff like that. But you guys did a very good job at all of that. By and large, you did a good job of linking your arguments to your factums as you went along. That's an important practical skill, because the judge may need to make notes to go back later and refer to when they are writing their reasons. And the Griffin, one thing you did really well, I liked your roadmap at the beginning. You laid out a very clear roadmap, and that's always good to signpost where you're going to go. One thing you might want to watch is, I caught you at least once with an unnecessary formality in your language. I think you referred to plans, and then you followed up with said plans. And, you know, there is, and this goes, some free writing advice at the same time. This goes true for writing as well, that sometimes we feel like we need to use sort of more formal structures as a way of making what we say sound more lawyerly or professional, when in fact it's much more effective if you write and speak the way you would write and speak, you know. So there's all kinds of articles out there about saying, like, don't say vehicle, say car, you know, just think about your language. So you don't need that extra formality to make your point. It can be a little bit distracting, and it can also hold your listener or your reader a little bit at bay. So the braver thing to do is to drop that stuff and communicate more directly. But you didn't do that very often. It was just one thing that I picked up. Sean, I thought one of the things you did really well, I noticed you were, and it's harder even on Zoom, I think, than it is in a courtroom, but you were watching. And so at some point when Justice Papagiorgio took a breath, you stopped what you were saying because you were anticipating her asking a question. That's really responsive cue reading. So you were picking up on her body language, you know, and watching three of us while you were delivering your submission. So that's a really good thing to do. You also referred to PDF pages. And I can tell you, I've done so many CLEs lately where I'm ranting at lawyers to please start bringing electronic page references to hearings. Now that we're all online, you'd think they'd have figured that out by now. They have not, many of them, but you had that down. So, and it was good because I was actually in the document and I could just type in and get to the page. So that's very, that was really a good thing to do. There were a few times I noticed you rocking a little bit, so you might want to watch that, but it wasn't very distracting. And Maya, you know, I have heard so many pleadings motions where nobody goes to the pleading. So good for you for actually referring to the statement of claim and making the argument centered in what was in the statement of claim. That was a practical approach that, like I said, I regularly don't see from lawyers. So to see it from a law student is really great. I thought you handled some tough questions very well. And the one thing at the beginning, you said, I will submit a few times. And I'd just say to you, that's kind of along the lines of the comment I made to Griffin about said, like, you don't have to tell us you're going to submit it, just say it. In fact, my rule of thumb in factums is you're allowed to say submit once, and that's at the very end where it says all of which is respectfully submitted. And otherwise, you should do a search for the word submit in your factum before you finalize it. And if you find it anyplace else, you should take it out. Dylan, I thought you moved along very well at the beginning. There was you slid along quickly and moved into your points when Justice Winkler hit you with some difficult questions at the beginning about the Attorney General, and you kind of just pivoted and moved into your submissions and kept your composure. I thought that was really good. So yeah, all in all, you guys did a great job. You were better than many of the lawyers who appear before me, and I'll look forward to seeing you in front of me next time in your robes.
So I don't have a lot to add. I also thought that you all did a really good job. You know, you were prepared, you knew your material, you made good eye contact, your pace was good. Those are my general comments for all of you. I'm just going to, so I don't have individual comments for most of you, but I do for Mr. Grohe. So I thought that you had the hardest argument to make. You really did. And I thought that you did a really good job answering the questions in the context of having kind of a difficult argument to make. And so you did some very quick thinking on your feet. You were very clear. You took your time to think about the questions and answer. And you started off, I like this, with this was part of your thinking on your feet. You saw that your teammate ran out of time and then couldn't finish something. And then you immediately started with, you know, you can do this, you know, if you don't like the class definition. And I thought that was really good. And you did that throughout. And I thought that was really excellent. One comment that I'll make for all of you, and I'm not sure that my co-panelists would agree with me. But one of the things I've seen is that sometimes people show up to court and they're really nervous, and they're kind of afraid of the judge, and they think the judge is going to yell at them, or I don't know what it is, but they're quite timid. And I would encourage you not to be timid, because I've had people come where it's like something has happened and then they don't advocate strong enough because I initially rebuff them and I say, well, I don't agree with that. And then they completely stop. And then when I'm writing it, I go back and I look at the issue and I think, oh, they were completely right. They should have, said more. So I, in my opinion, you know what, you try something once, the judge doesn't like it. I would try at least one more time, and try to make the argument, because sometimes we just don't understand it, because maybe you're more familiar with the material, like you've been working on it for days and months, and we get it and we read it, but we don't have the same familiarity as you. So, but other than that, I thought that you were all excellent. So I'm very grateful to have been here.
So
Alrighty,
thank you very
thank-
much. Those are, that kind of wraps up our, our comments for you. And so again, what a pleasure it was. So what do we do now, Jesse?
Alrighty, so we're going to go into a 10-minute break, but before we do that, I just want to take the time to obviously thank our finalists, but also thank our final panel. You know, we appreciate you taking the time this afternoon to be with us, Chief Justice Winkler. It's always a pleasure to have you. Justice Papageorgiou and Justice Akbarali, this was great, and it was just a pleasure to have you both here. And I think I'm probably speaking for the mooters when I say that as well. The comments, I think, seem to have been appreciated from the head nods that I've seen. So we really appreciate you taking the time today. We ask that if you want to stick around for the fireside chat with Chief Justice Winkler, you're more than welcome to do that. And then we're also going to announce the winners, the various awards after the fireside chat. But we understand if your schedule does not permit that. I know Justice Akbarali was writing reasons this morning, so if you have to get back to that, we totally understand. So we will take a 10-minute break just to give everybody time to go to the bathroom, take some water, coffee, whatever is needed, and we'll be back in at 5:47 p.m. for the fireside chat with Chief Justice Winkler. Thank you, everyone.
Thank you.
Thank you so much.
Thank you.
I will be leaving